Welcome to today's presentation, the u-vsa, establishing relief for victims of criminal activity. This presentation is brought to you by Goldman & Laughlin Law Firm, the immigration-only law firm. Please visit our website at www.usimmigrationteam.com. Before beginning, I'd like to read a brief disclaimer. The information provided today is offered for general education purposes only. You know that each case and its circumstances are unique, and it is therefore not possible to give specific advice on any individual case in a presentation such as this one. Although the authors and presenters are immigration attorneys, the information provided in this presentation is not legal advice. If you do require legal advice, please make an appointment or contact an attorney of your choice. Let's get started. What is a u-vsa? Well, a u-vsa is a special class of non-immigrant visa that's been made available by an act of Congress to provide relief for victims of certain qualifying crimes. And we'll learn about that in a moment. But you cannot obtain u-vsa relief only by being a victim of one of these qualifying crimes. The qualifying criminal activity must also have been committed in the United States, but this does include Indian territories, military installations, and other territories and possessions of the United States. But even that's not enough. The victim must also have information about the criminal activity, and the victim must have been helpful, is being helpful, or is likely to be helpful to the investigation or prosecution of the qualifying criminal activity. Let's discuss the general benefits of a u-vsa and u-vsa status. There are many. The first thing is that the victim need not be physically present in the United States in order to apply for benefits. And if granted u-vsa status or a u-vsa, lawful status is granted typically for 4 years. And during that time, the individual will be eligible for work authorization. That is, they will receive an employment authorization document allowing them to work in the United States. Further, after 3 years in this status, they may be eligible to apply to adjust status. That is, they may be able to apply for a green card. And, important to many people, is that if they have qualifying family members and they obtain a u-vsa or u-vsa status, the derivative family members may also be eligible to obtain the status as well. Now, there are 2 other areas, there are benefits that are frequently overlooked, so I just want to touch on them lightly. The first thing is that even if someone already has a green card, that is if they're a lawful permanent resident, but they're in immigration proceedings, in removal proceedings to deport them from the United States, they may apply for u-vsa relief. In addition, even someone who is not a green card holder but is in immigration court in removal proceedings may also apply for u-vsa relief. Of course, this is subject to them being eligible to meeting the general eligibility requirements for a u-vsa. But I say this because if you are in immigration court or you find yourself there and you feel that you may be eligible for a u-vsa, it's important that you let your attorney know this as soon as possible. This is one of the most frequently overlooked forms of relief. What constitutes qualifying criminal activity? Well, the first thing you need to know is that this can occur at the federal, state, or local level. And the Act has enumerated a number of crimes and criminal activities. I will go through them in turn. Rape, torture, trafficking, incest, domestic violence, sexual assault, abusive sexual contact, prostitution, sexual exploitation, female genital mutilation, being held hostage, involuntary servitude, slave trade, kidnapping, abduction, unlawful criminal restraint, false imprisonment, blackmail, extortion, manslaughter, murder, felonious assault, witness tampering, obstruction of justice, and perjury. And also any attempt, conspiracy, or solicitation to commit any of these enumerated crimes or criminal activities as well. What constitutes a qualifying victim? The victim must have suffered substantial physical abuse or substantial mental abuse. And as you would imagine, these typically come hand in hand. And there's also what I like to call the nexus requirement. In other words, the victim's suffering must be a result of the underlying qualifying criminal activity. And there is also a certification requirement. What's this? A federal, state, or local official who is investigating or prosecuting the qualifying criminal activity must certify that the victim has been, is being, or will likely be helpful to the official's investigation or prosecution. Now, when you file a visa, when you file for a u-vsa, there's certain forms and procedures you need to adhere to. The first thing is that the standard form for applying is Form I-918, I-918. Important to know is that there is a supplement to this form. It's called Supplement B. Supplement B is to be completed by the prosecuting or investigating agency, and it must be signed by an authorized agency official. And once that's done, bear in mind that the I-918 and the Supplement B must be filed concurrently, and you must have a personal statement of the victim, particularly detailed. In this statement, you're going to want to outline how you meet all of the requirements for obtaining u-visa relief. So you should take your time with it. Make sure you complete it in detail. If the victim happens to be a minor, an adult parent or guardian or other authorized party can prepare the statement on their behalf. In addition to the standard filings, the Form 918, the supplement, the personal statement, which are all extremely important, there are some recommended supplemental documents that I believe should be included. First thing that comes to mind are police reports. If they're available, you want to obtain them, and you'll want to try to submit them with your application. In addition, if your case has gone on to prosecution, you want to get transcripts and or other court records and submit them with your filing. Affidavits of witnesses are very helpful. And don't overlook affidavits from family and friends who may have valuable information about how you were affected after this crime, mentally and physically. Try to get affidavits from the police officers or prosecutors you were working with. In addition to them filling out the B supplement, it's good to have some affidavits, if you can get them, to underscore the level of your cooperation and help. Look for news articles. Frequently there are news articles posted on criminal activities. If you don't have the paper version, most newspapers do have an online service to obtain articles. You should look into that as well. Photographs are very important, particularly if you have photos depicting your physical injuries after a qualifying event. Bear in mind, however, that you should submit the photos with an affidavit of authenticity. Finally, medical records and psychological reports. Perhaps you went to the hospital. Perhaps you have had ongoing medical treatment. Psychological reports are effective for even years later in cases. Why? Because frequently the psychological trauma goes on for many, many years after the qualifying crime or criminal activity. And more. The reason I say this, any documents or evidence that you feel would tend to show that you meet the requirements for obtaining u-visa relief should also be submitted. Another thing to bear in mind, I've been saying to submit this documentation with your initial application, and that is true. However, the agency has been somewhat liberal in accepting ongoing supplementation in these cases, and it's presumed that that will continue. But ideally, if you have as much documentation up front before a decision is made in your case. This has been a presentation on the u-visa, establishing relief for victims of criminal activity. And again, this presentation is by Goldman & Laughlin Law Firm, the immigration-only law firm. Please take a moment to visit our website at www.usimmigrationteam.com for more information.